Good evening, everyone. Welcome to the Town of Carmel Zoning Board of Appeals meeting for the month of January. Happy New Year, everyone, 2024. Board members' names are in front of you on the dais. Code Enforcement Officer Mike Carnazza is with us, as well as Town Council Greg Fulchetti. The way we operate is we'll ask you to come up, present your case. I'll swear you in if you're not of council. Then you present your case. We'll poll the board for any questions or comments, and then we'll open it up to the public. Once a case is closed, there is no further input from the public, so please keep that in mind. And I see there's some cases here tonight that might have multiple speakers. Everyone's entitled to come up and speak, but if you're going to keep saying the same thing, let's keep it to a minimum, or have one representative speak on behalf of a certain group or whatnot. Will you all please stand and join me for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. Our first case tonight is a holdover. Altero. I think, yeah, we got a note this afternoon. This is Willie Bacherat, right?
Yeah, this is Willie.
That he's not feeling well, and unfortunately may have had to go to the hospital, so we'll give him a pass on this one. Hope he's feeling better. Excuse me. I'll look for a motion to hold this application over.
So moved.
Second.
All in favor?
Aye.
Okay, thank you. All right, application number 2 is Cottage. And I will read this. It's for interpretation of section 156-15. Applicant owns the parcel upon which the temporary dock is located and the parcel improved by at least one residential dwelling unit, which is directly across the street but separated by a road, i.e. East Lake Boulevard. Applicant seeks an interpretation that the intent of the statute, i.e. a dock, when not located on a parcel improved by at least one residential unit, is met under the circumstances set forth herein, or, in the alternative, the following area variance tax table below. The property is located at 148 East Lake Boulevard, Mahopac. It's tax map 76.30-1-5. And the code allows or requires lake frontage of 50 feet. What's provided is 6.25 feet, so a variance of 43.75 feet is required. And then the code allows or requires a minimum variance of 3,000 square feet. What's provided is 280 square feet, so a variance of 2,720 square feet is being sought. Good evening.
Good evening, Mr. Chairman, members of the board. Happy New Year. Frank J. Smith III, Law Office of Schilling and Smith, on behalf of the applicants.
These gentlemen are all going to be speaking?
Correct.
All right, state your names, please, for the record and address.
I am the owner of property, 143.
What's your name and address? Use that microphone,
Use the
please.
microphone.
Is Vieco Cottage, the owner from 143 East Lake Boulevard.
And you are?
Jovan Kotash, 34 Kayla Lane.
All right, can you raise your right hands? Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
I do.
Thank you. Okay, Frank, sorry.
Thank you,
Just wanted to
Mr.
get
Chairman.
that
Not a problem. Again, I'm joined tonight by Vieco and Jovelyn Kotaj. The property is known as tax map number 76.30-1-5. It consists of an undeveloped lot that is 6¼ feet wide and roughly 45 feet long. The relief requested this evening is in the form of an interpretation, or in the alternative, an area variance. First, I respectfully request that the board utilize its interpretive powers related to section 156-27 of the code. That code section states, quote, "A private dock, when not located on a parcel improved by at least one residential dwelling unit, shall require minimum lake frontage of at least 50 feet, a minimum mean depth of at least 30 feet, and a minimum area of at least 3,000 square feet." In this instance, the parcel in question, although not improved, is bound by deed to a parcel that is improved and merely separated by East Lake Boulevard. This is not a standalone lot, and the single deed includes 4 tax parcels. Therefore, I'm asking the board to interpret that in this instance, the parcel is, quote, improved for purposes of the statute. Should the board reject this interpretation, I seek an area variance for lake frontage and minimum area. In this case, the frontage required is 50 feet. The applicant provides 6 1/4 feet, requiring a variance of 43 3/4 feet. Additionally, the code requires a minimum lot area to be 3,000 square feet. The lot in question is 280 square feet, requiring a variance of 2,720 square feet. The lot is compliant with average depth. Prior to the hearing, in support of the application, my office submitted a completed zoning board application, a survey of the parcel, photographs, an affidavit from Realtor Gary Margolis, who states that the loss of the dock would result in an $80,000 to $100,000 devaluation of the property, a letter of no objection from Benjamin Jung of Lake Mahopac Condominiums, and I subsequently submitted additional maps and a copy of an easement that encumbers the lot. A brief history. The parcel in question is one of 4 parcels contained in one deed. The 2 lakefront parcels are known as tax map numbers 76.30-1-5 and 76.30-1-7. The third parcel is known as tax map number 76.30-1-20, and the fourth parcel, which is improved by a residence, is known as 143 East Lake Boulevard. The parcel has been in the family since 2010, but has been owned by the applicant and her husband, Vieco, since 2017. The purpose of acquiring the property was to ensure access to the lake and use of a dock. The applicant believed that since there was a single-family residence across the street and bound by deed, the dock would be permitted. Again, the lakefront lots were conveyed together with the residential home in one deed. Tonight, I respectfully request that the board utilize its interpretive powers related to Code Section 156-27. As previously mentioned, the code section requires that a private dock, when not located on a parcel improved by at least one residential dwelling unit, shall require minimum lake frontage of 50 feet, minimum mean depth of 30 feet, and minimum area of at least 3,000 square feet. It appears clear that the spirit of the statute was to impose minimum dimensional requirements for standalone lakefront lots that are unimproved. That is not the situation here. In this instance, the lakefront lot in question is deeded with a single-family residence on East Lake Boulevard. If the road did not intersect, the dock lots and improved lot would be contiguous. The town has a valid concern in regulating standalone lots, which the applicant and I recognize and fully appreciate. As such, the applicant would agree, as a condition to approval, that the lakefront lots never be separated from the other 2 lots and always conveyed with the single-family residence located on East Lake Boulevard. For the preceding reasons, I respectfully request that the board interpret that the subject parcel is considered improved under the statute. Again, if the board should reject this interpretation, I respectfully request that area variances be granted related to frontage and minimum area. As the board is aware, there are 5 criteria when considering an area variance. First, and most importantly, is whether granting the variance would result in a negative impact to the neighborhood. Second is whether the need for variance can be obviated. Third is whether the variance is substantial. Fourth is whether granting the variance would result in an adverse environmental impact to the neighborhood. And lastly, whether the difficulty was self-created. For the following reasons, I respectfully contend that the applicant meets these requirements and that the variances should be granted in all respects. First is whether there would be an adverse change to the neighborhood. In this case, there would not. This area of the lake is home to a number of small lots that provide lakefront access. Additionally, neighbors to the north include the local VFW post and a commercial establishment that provides for the docking of boats to utilize a restaurant and bar. Should the board grant the variance, there would be no negative impact to the neighborhood. Second is whether the need for variance can be obviated. In this case, it can't. This is a very unique series of parcels, which I've described before. The applicant owns the parcel in question, which is contiguous to a parcel owned by Lake Mahopac Condominiums. Then there is a stockade fence, and on the other side, a similar lot owned by the applicant, which is then contiguous to a similar lot owned by the Lake Mahopac Condominiums. It's kind of a patchwork. The applicant has tried on numerous occasions to swap the lots with the condo to make for 2 contiguous lots, and that request was denied. That request was again denied in December of 2023 following our last appearance. Due to this, there is no other way to achieve the desired outcome without the variance, and therefore it cannot be obviated. Third is whether the variance is substantial. In this instance, the variances requested are large. However, they seek to legalize what has been in existence for a number of years. For this reason, I argue that they are not substantial. In addition, the lots are deeded with the single-family residence. Much like in our request for interpretation, the applicant would commit to a condition of approval that the lots never be separated and always conveyed with the single-family residence located on East Lake Boulevard. Fourth is whether granting the variance would cause an adverse change to the surrounding environment. In this case, it would not. As previously mentioned, the lot has been utilized with the dock for a number of years. It is also located 2 doors from a commercial establishment, which has boats come in and out on a regular basis. I respectfully argue that if granted, there would be no negative impact to the environment. Lastly is whether the hardship was self-created. In this instance, it was not. The lot has been in family ownership since 2010, and at that time, the lakefront lots were the current size that they are now. The applicant did not create these lots, he merely purchased them and is seeking to legalize them through this board. For this reason, I argue that the hardship was not self-created. Tonight, I respectfully request that the board utilize its interpretive powers to determine that the lot in question is improved for purposes of the statute. If the board does not reach this conclusion, then based upon the foregoing, I contend that the applicant meets the area variance criteria and respectfully request that the variances be granted in all respects. Prior to questions from the board and comments from the audience, there are a few items that I believe necessary to address since our last appearance. Today, this board received a letter from Mr. Barilli submitted in opposition of the application. In this letter, there was a series of photographs purporting to show that there was no dock in the past. I would like to correct the record. The last time that I was here, I had represented to the board that the dock had been in existence since at least 2017 when the applicant took ownership of the property. The dock was in fact added later than that. It came after a lawsuit, which I will describe momentarily, and my client will answer any questions related to the history of the dock and how long it's been there. What the photos actually showed was that the property to the left of ours, known as 144 East Lake Boulevard, the owners were utilizing my client's parcel as if it was their own. Because of this, my clients brought a lawsuit against the owners of 144 East Lake Boulevard, seeking to prevent them from using the parcel that they own. That litigation resulted in a stipulation of settlement, and furthermore, the neighbors obtained an easement over my client's property. That easement has been provided to the board. Today, the owners of 144 East Lake Boulevard, who have a property right to my client's property, are seeking to prevent him from using it the way in which he would like. That reeks of unfairness. As previously noted, we reached out to Mr. Barilli multiple times to discuss the application, and he would not entertain any discussion. Additionally, it is my understanding that our neighbor to the north, the VFW, is in opposition to the application. This opposition is for reasons unknown. As previously represented, my partner, Bill Schilling, had communications with a VFW member named Chris Long. A letter was sent to the VFW in August of 2023, and that letter was read at that month's VFW meeting. There was no indication of opposition nor support. We welcomed the opportunity to discuss the concerns of the VFW. Then again, in this past December, my office sent a letter to the VFW post commander. This again was an attempt to discuss the application and to mitigate any concerns that existed. We never received a response to that letter. Lastly, following our last appearance, we once again sought to swap the parcels with the condominium. Although the condominium has provided us with a letter of no opposition, they rejected our request to swap the lots to make them larger. In sum, I ask the board to understand that the applicant is aware of the difficulties associated with this application. We have tried to speak with our neighbors to mitigate their concerns, and those efforts have been ignored. I thank you for the opportunity to present. Myself and my clients are available for any questions, and we'll address the public comments afterwards. Thank you.
Okay, so in December, I missed that meeting, unfortunately. It was early December, right? At the meeting prior to that, we had asked about swapping the lots. And that
Correct.
definitely is out. Just to bring me up to speed, right? So, you know, that's where you're in a tough situation, because right now, your lot, the only lot that's utilized is right up against that existing house.
Correct.
Okay.
And again, it's our lot, about 6¼ feet wide, the condo lot, about the same size, our lot, and then the condo lot again.
Yep.
And then the VFW, and then the restaurant.
It's a tough one. I'm going to open it up to the board for any questions, comments.
Looking at, you know, thanks for providing the site plan, the existing conditions. So 6.282 feet by 44.44 feet, or 45.18 feet, which is, got some depth, and it's not, that's not a lot of width. You're proposing a dock, it's 4 feet wide.
3 feet wide.
3 feet, okay, it says 4 feet on
Oh,
this. 4 feet by 24 foot
Okay.
in black and white. Nonetheless, 3 foot or an additional foot, you know, if that was there, we would ask if the folks from the Board of Managers of the lake, if they wanted to put a dock there, they would come in too. But I don't think they'd be able to fit a 3-foot dock on them without being on your property and having a boat or a pontoon that would encroach onto your property. Likewise for the Mahopac unit, the realty people. If they have
They're the
4
same.
foot, okay? It would also go onto your property.
The only point that I would like to make related to that is that north of the restaurant, the condominium, which is also Lake Mahopac Units Realty, they're the same entity,
It's a
different name.
condominiums.
They do have a beachfront, and they do have access that is north of the restaurant. That's where they utilize lake access. Again, they submitted a letter of no opposition. I can't give a reason why they denied our request to swap.
I think you're just in an unfortunate situation where it's a tight lot broken up by 4 parcels, and it's a tough go-around. Unfortunately, it's just the nature of the way it was divided originally.
Just a question to Mike, you know, these parcels, they were meant originally you know, for just access, like to the lake.
Yeah, just for
basically. It's just
swimming.
you have access.
I assume, but that's an assumption. I don't know.
Okay, it's
I mean, it's not,
6.25 feet.
it's not as wide as a boat, so.
Yeah, I mean, you're gonna put a 3-foot dock, and then a boat's gonna be at least 8 feet if it's a pontoon, or 6 feet, you're gonna. 8 feet. Right, that's my point in case, you're gonna encumber someone else's access on the rest of those 3 lots to the lake, or they wouldn't be able to put up a dock or a boat. It's just an unfortunate situation, the way the lot is.
We did see the photos, I'm sorry.
No problem. Just how.
Just speaking to the mic, this is being recorded
No,
for
no problem.
minutes, so
Just how Frank said, they have, both of the condominiums, whatever, the owners, they have access to the lake. They have their own beachfront, and they have access with, they already have docks and boats on the other side. And when we spoke, I think they spoke to them, they said that they don't plan or ever in the future putting on a dock or a boat in that area. Or they never even, we always told them they have access to come anytime, but they don't come over there, you know.
Yeah,
but
they
that
probably
doesn't
more
preclude-
convenient for them to be at their larger beach. It's
Exactly.
easier access. You know, the variance is for forever. You don't know who may own that later. You know, it's forever,
So that,
right?
but that doesn't preclude a future owner from having the ability to access the lake at that point.
You know, they shared the photos of the neighbors at 144 East Lake. You know, that tells a lot. You know, a picture tells a lot when you see that kitchen. You're right on top of your dock. You know, you're right there. And you know, to get on and off a boat, I mean, you'd have to almost use that house
I mean, the
to
ideal
steady
thing,
yourself. That's a
Jonathan,
small area.
If I may, the ideal thing would be the 4 owners getting together to create some kind of homeowners association
Yes.
with one dock going out, then houses, whatever, but you're not able to have that accomplished, unfortunately, for you.
Yes, we are very close to that dock, but I don't know how he get approval where he built the house. If you look the survey, my poles is exactly corner of his house. That legally, if you want to go that, you need minimum 2 feet or 4 feet to be from the property. And he get approval. And we don't have approval, that is removal dock. It's not like a full to stay there permanently with the concrete and stuff like that. My dock I buy from Lowe's. You can remove anytime, you can install. It's only for the summer. And last hearing, I know was here, where he said somebody put fingerprints in his window. That is not true. Number one. Number two, he have camera there. If it was that true, he can pull out the camera who put those fingerprints. He can do by his own because he have a generator in my property. He need to walk. If you want to go to generator, he to go over my property because he no leave room in his house.
You said
Everything
there's
is
an easement,
all
though?
the way.
He has an easement?
Yes,
So he
I
has the
need
right
to give
be on
him
that
easement
property?
because he need to maintain a generator. I try to be gentleman from the first day I am there, but and for my 55 years, I share very friendly with all the neighbors. I don't know what I did
We understand that. We
bad
can't-
to
we're not
my
here-
God, to
We're not
God.
here to argue neighborly
No, it's
disputes.
no
That's
argument.
between-
But my first time for 55 years, I need to go somewhere to have a judgment or something with the neighbors or with somebody else. We are always just peaceful, friendly, share, neighbors, love. Mother Teresa say, love your neighbors how you love yourself. I am
appreciate
Albanian, blood of Mother Teresa. But I am very surprised how I deserve to have neighbor like that and to have all those issues from no reason. And later on, I catch it. I am no first person who have deal with them. Because I was thinking
Okay,
it's
we're-
my...
Again, we're not going to get into.
No, I don't
neighborly
want to go
disputes
nowhere,
and
but the
disagreements.
story
So
is-
facts here are in front of us. You
Yeah,
can
yeah.
keep that speech for
Yeah.
another time for someone
Okay,
else.
thank you,
The
thank you.
facts are in front of us about what we're here to interpret. So.
The
or-
only point that I would make related to the proximity of this lot and the house next door is that even if there was no dock there, my client could go set up their beach chair and sit outside and be
Correct.
right next to
Most
that
certainly,
kitchen window
correct.
anyway. If you look out the kitchen window, it's not too far. You see a number of jet ski lots. I think there's an open question as to whether all of those boat docks on the VFW property are within the four corners of that property. That's a question for another day, but there are photographs that show a large dock in its close proximity.
Well, that's for another day, like you said, or for someone else to discover.
Yeah,
So
so,
the case in front of us is what we're here to discuss.
that's right. We're just trying to interpretate this properly, correctly, and it's permanent, okay?
Understood.
So, when you look at the area variance, is it substantial? It is substantial variance. It is a very substantial variance because it impacts the next parcel. You're encroached already onto that parcel.
Both parcels,
Yeah,
both
both
sides.
parcels on either side. So it's very substantial. And is it self-created? Yes,
But that is sharing lot. It's not like I go from one to other.
I got it.
And I asked one time Mike Carnazzo where he put the Sphinx shed, Barelli, and he says the reason he make that lot like that to nobody build nothing because it's a small lot. If you share by 6 foot, it's like just to use it, but not to build something. And what the gentleman says, my lawyer, if we making a barbecue and party like VFW, what he making there, he can be much more noisy. No, what we doing, just park the boat, go to the lake and come back and go straight out to my house where I live and we have parking lot and everything. We no bother nobody. I bother my neighbors because I have my broken English. He was thinking if I come from some other country, he was thinking this is no deserve that, and he was thinking all the lake is for him. But the reason I have that lake, I buy the house against that property in the lake. Because I come from the town, Montenegro, we live by the area, water line and stuff like that, and that's the reason I'm here. And I pay for this town over $50,000 taxes, and I think I deserve to live normal like anybody else. Thank you.
Yeah, thank you.
Rose, do you have anything?
Yes, I have a few things. I think what's important to consider is looking at the criteria. Frank, you spoke about the first criteria, will an undesirable change in the neighborhood? No, it won't. However, there's a second portion of that criteria that you failed to mention, and that is, or a detriment to nearby properties be created by granting of the variance. Yes, certainly, someone who doesn't want smoke going into their house from a diesel engine, they don't want to have someone leaning on their house to get onto their boat. That's a problem. Can any other method be used? Probably not, because the lot is too small. Is the proposed variance substantial? My calculations, it looks like the minimum lot depth is 88%, and the minimum area, you only have 280 feet when there should be 3,000. That's a 93%. That's 93% variance. That's substantial by any criteria. Will it have a proposed variance have an adverse effect or impact on the physical or environmental conditions in the neighborhood? Probably not. Is it self-created? I think so. This property, I think, was put there as a swimming area, not as a boat dock. If you have 6 feet and 3 feet's the dock, then you have 3 feet. I'm not a mathematician, but I don't think any more than a kayak could fit, is less than 3 feet. I don't know. I don't know boats in the area. But I would think you can launch a kayak, but that's about it when you have 6 feet and then you have 3 feet for a dock. So I just can't see this working in any way, looking at the area variances. It just doesn't add up. You know, a pontoon boat, if that's what your intention is, that's wide. What is that, 6 feet wide?
It's at least 8 feet,
8
6
feet
inches.
wide.
Minimum.
So how do you have 8 feet wide
Bumpers.
and a 6 foot? Just doesn't make sense.
My only response would be the letter of no opposition from the neighboring property owner.
What happens if a new board of directors goes in, or they decide to sell that whole condo complex and somebody decides to put in another
I
house?
think you would need something stronger, Frank. You have to. Because that's, you can't bank on that forever. You
No.
just can't.
Not on an
A new
agreement.
board might bode well for you. They might be in agreement to doing a shared property.
But you
or
have to have some
something.
type of covenant there. That's dangerous. Because then if they turn around and say you can't do it, then what are we doing here? You know? That's my biggest fear. You gotta get some better commitment from that condo board.
I mean, you guys said you tried, and that's why I keep saying it's unfortunate if they
Right.
can't comply with you. You don't have a choice.
Puts us in a bind.
Yeah, if you're together, I mean, you can,
100%.
It would be
very
nice.
doable.
100%.
Right in the middle
If
there
there's some
or
type of covenant there, this is a much different conversation.
Exactly. Julie, do you have any comments, questions?
I
Will?
stole yours.
Do you have anything to add? All right, at this point, I think I'm going to open it up to the public, because we have some folks here, I believe, to speak on this application. So if you guys don't mind taking a seat, so we can give them
Thank you,
the-
Mr. Chairman.
Thank you, guys. Anybody wishes to be heard, please come up, fill your name and address on that piece of paper before you leave the podium, and state your name and address.
Hi, Nicole Stern. I own 144 East Lake Boulevard, the direct neighboring property.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thanks.
So.
Nicole, you can
today-
speak into the hand mic if you'd like to, or that turns down, you just twist it down towards your mouth, it should pick you up. Mike, twist, there you go.
Okay, couple things. First, I think it's important that my father was not able to attend tonight, and I think it is important that I read the letter that he wrote for the record and for everyone listening. That way they know what it said, because it also mirrors my feelings.
Certainly.
Chairman and members of the board, my daughter and I have owned the neighboring property, 144 East Lake Boulevard, for over 30 years. Mr. Kotaj purchased a multi-family rental property across the street from our property for investment purposes, deed dated 2016. With that multifamily purchase, he also took ownership of 2 non-adjacent 6-foot lake parcels next door to my home, showing there is no financial hardship. There are 2 additional non-adjacent 6-foot parcels owned by the condominiums next door to me as well. A few years ago, Mr. Kotaj took it upon himself, with no permits and without speaking to any of his neighbors, to build a dock for his boat. A dock that is still there today, although asked by this board to be removed last year. See attached photo that was taken last week. I believe you all have copies of everything. The dock that was constructed does not remotely meet the variance requirements for the town. Should this dock be approved, this board is single-handedly opening the floodgates to allow all substandard lake strip owners to construct docks on their properties on an already overcrowded lake, which I witnessed firsthand, having resided on the lake for over 40 years. The dock is approximately 3 feet wide, and Mr. Kotaj owns a pontoon boat with a beam of approximately 10 feet wide. This inhibits the neighboring lake strip owners from accessing the lake via their parcels. It infringes on the privacy of the occupants in my home, and it also causes a strain for the VFW members to access their boats and jet skis that are parked in legal dock spaces. Not to mention, it is wider than the property that Mr. Kotaj owns, even if his parcels were adjacent. I have been attending zoning board meetings for approximately 1 year to express my opposition to the application submitted by Board Kotaj. There is no hardship here. These parcels belong to an investment property that he owns. He resides with his family in a premier neighborhood on Kayla Lane in Mahopac, where homes sell for over $1 million. The application for variance was self-created, and the dock did not exist prior to Mr. Kotaj's ownership, contrary to the lies he has told the board in the past. See the time lapse of photos from 2012 to 2022 attached. We have all been told over 3 months ago that this board would vote on this application in order to stop the endless holdovers of this case. However, 2 more extensions were granted. The endless holdovers of this application simply enable Mr. Kotaj to, year after year, continue to use his illegal dock. I would expect a vote to take place tonight. Continuing to hold over an application of this nature will not change the fact that it does not comply with the laws expected to be upheld by this board. So that was my father's letter, but I have a few other thoughts I'd like to add after listening to what they had to say. First of all, there's no way that the beam on the pontoon is only 8 foot. I have 30 boat slips at Lake House Restaurant, and we specifically cannot fit pontoon boats because our widest spot is 8'2", and pontoon boats are always wider. So I know for a fact it's not 8 feet. I would say 10 feet is a safe estimate. In terms of the statement regarding how did we get approvals to build our house on the property line, that house has been there before my father or I walked this earth. It has been there over 100 years. It was renovated by us probably about 20 years ago, keeping the same footprints of what was there. So that was not built by us. Nothing was scammed or schemed in the permitting process. That was there before we all existed.
It's conjecture, it was approved anyway by Mike's
The
department.
generator is on our property. It is on the solid foundation of our property. And that's why there is an easement to access it, because all of the parcels around the lake are all butting up to each other. Regarding the letter of no objection that they keep referring to, I believe, if memory serves me correctly, and tell me if I'm wrong, I believe when you read that letter of no objection, it specifically stated that there was no objection as long as whatever he built did not obstruct their parcels. And this is a blatant obstruction of all the parcels. So that letter of no objection, it really doesn't stand. They stated multiple times it's a single-family residence. According to MLS Realist, which usually mirrors the tax records, it's a 3-family. It's not a single family. So unless MLS or the tax records or something is wrong, it is listed as a triplex. There's also no stockade fence in the middle of the lots, as stated. Regarding us maintaining the property before they owned the property, that is correct. We, like I said, had owned the house for, I think my dad's letter said 30 years. It's probably closer to 40 years. And we always mowed the lawn, maintained the property. My kid's swing set was there. Regarding the lawsuit he said was stated, there was no lawsuit. It was emails that were sent between Mr. Schilling and my attorney at the time, Jennifer Herodes, to discuss the fact that they purchased the property and wanted access to their strips. We negotiated back and forth through emails to come up with a mutual agreement where we had an easement, they had access, and here we are. And I think that's really it. So as you can see, we strongly oppose this. It has nothing to do with any lawsuit or past issues, just the fact that it's encroaching on my tenant's privacy, on the VFW. It's just not right. It doesn't meet any of the variance requirements, and I do believe that you guys will do the right thing.
Nicole, can you just explain these pictures? Are these on the actual lot?
That's on the lot. That was when we were building the really major nightmare of a Toys R Us swing set. So
But it's no longer there.
No. That was
Okay,
back
it's
when
been
my kids
removed.
were little when I lived there.
Okay, that's what I-
So that was in 2011. My son was 2 years
You have all
old.
this nice mulch and build up?
That's
and-
my
Yeah.
son's third birthday. That was when we were still maintaining the property. That was to show that there is no dock behind there, because in prior meetings, they had stated that the dock was there when they bought the property, which
All
was
right, so these
false.
pictures were taken from those dates? back
Those
in
are Google
2016?
Earth images where you can.
So they're documented?
Yes,
from
that's
your-
what we
okay.
circled in red, the actual dates. It was hard to
Yep,
read, so
okay.
we also typed it on top to show that they built the dock, I believe it was in 2022. They had stated it had been there for, 10 years, which is completely false.
Okay, and it's hard to see, but that's actually a pontoon boat in that last
Yes,
picture?
and that pontoon boat takes up all 4 of the spaces, touching, like I said, they touch my tenant's kitchen window while they're on the dock. It's extremely uncomfortable.
Okay. Do you have anything else?
That's it. Thank you very much.
Thank you.
Actually, if you have a 3-foot dock and then a 10-foot pontoon, you're into 13 feet. So you're
Yeah.
going beyond next door and then going on to his lot again.
And then you have the buoys in the middle or some sort of space in between because it's not touching the dock. So you're looking at a 14, 15-foot, so that's what I was saying. Even if the 2 6-foot parcels were together, he's still going over that.
Yeah.
It just doesn't work.
It's tight.
Thank you.
Anybody else wish to be heard? Nicole, did you write your name and address on that piece of paper?
She did.
Luke Rashmith, 8 Veggie Lane, Mahopac, New York. I'm also,
Luke, right hand.
oh, sorry,
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
I'm just here on behalf of VFW, I'm the commander of the VFW. I don't want to talk.
No,
not to
just
you.
talk to us. Talk to
Okay.
us. Direct-
So we
direct
did
all
receive
your comments
his
to us.
letters. It was purposely not answered because of situations we had prior to that, which I'm not going to get into because it has no purpose here. He talked to a past commander at the post, which was brought up in our meeting, and it was absolutely opposite of what they stated. If he talked to me from the beginning, he would have known that right after our meeting. But Chris Long wasn't even at that meeting. I presented it to the members, and it was definitely 100% the other way. Really, everything else I have to say would be repeating. Just leave it in
Are there
your
minutes
best
that
judgment.
reflect this, either one way or the other?
What's that?
Are there minutes that reflect this either one way or another?
As of, in
the
mine?
meeting,
Oh,
yeah.
correct, yeah. Oh, we have minutes of every meeting.
Do you?
I can get those, yep. I can email them to you if needed, but
Sorry, so you're oppose or for?
Opposed?
opposed.
He's sworn.
Okay. Anybody else wish to be heard on this application? State your name and address.
Robert Kearns, 30 McAlpin. I live right here in Mahopac. I'm going to speak on behalf of the VFW as well.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do. So I'm going to come up here and pretty much reiterate what everyone else said. Luke and Nicole pretty much covered everything that I had to say, but I just wanted to make it very well known that the members at the VFW and myself are strongly against this dock. Nicole said it perfect. It takes up all 4 parcels. I think members of this board even stated that what if the Mahopac condominiums were to sell those parcels? What would happen then? Mr. Kotosh here has had arguments with members at our post coming in and out of his slip. He has yelled at members that our boats were in the way, and it's just opening an issue that we don't want to have at the Mahopac VFW. I've been observing him here in the crowd, and he seems to be very upset. And I'm just,
Let's keep personal feelings out.
Right.
all I'm going to say is that
Just to the subject.
I strongly disagree with this dock. That's all I'm going to say.
I guess more of a question for Luke as the commander, but there was a statement about your guys' docks and boats. You've all been passed and vetted out, right, through the town building department, right?
As far as I know, they're legal.
Correct, yeah, our spaces
Yeah,
are
Luke,
legal.
if you wanted, just answer to that in
We
case
we
someone's got a
improved our
question.
docks, I can't remember the exact year.
I think it was
I've been in
2014.
2014, could be corrected. I've been a member there 15 years now. We redid our docks, but they're on the exact footprint of the old docks were there. We just replaced them to aluminum, less maintenance.
Okay, so you're
And I'm pretty
grandfathered
sure-
in from,
What's that?
you're grandfathered in from,
Correct, from the previous.
okay. Just wanted some clarification, I'd appreciate that.
Thank you.
All right, anybody else wish to be heard on the application? All right, Frank, I'll give you an opportunity to respond.
Thank you, Mr. Chairman.
Hey, guys, you
guys,
gotta address the
not
board,
here, not
okay?
here,
We're gonna keep this right here.
Not here.
Just a couple of items. I have 8 copies here of certain documents that I'd like to provide to the board. The first one is the stipulation of settlement of the lawsuit that was stated did not exist. It did exist. It was settled through stipulation of settlement. There's a second copy of the easement agreement. I also want to provide the board with a copy of the letter sent to the VFW. And I would also like to read into the record the response that we received from the VFW after our first request.
And was that by the commander at the time?
No, that was by Mr. Long. I don't know what his position was at the time. He was the representative who would speak with us. Our letter was dated August 16th, 2023. We received a response from Mr. Long on August 30th, 2023. That response reads, "Hi, Bill. Yes, your letter was read at this month's meeting. I believe everyone understood what your client is trying to do with just being able to keep the existing dock and that it would be highly unlikely for the other property owner to obtain the proper variance to build their own dock. With that being said, I personally cannot guarantee that one of the vets doesn't show up at the next meeting just to hear what may or may not happen. If there is anything else I can help you with, please don't hesitate to contact me. Respectfully, Chris Long." So I do have 8 copies of these documents to be put into the record, one each for the board, one for our clerk.
Well, I mean, Frank, we're not gonna have time to sit here and read it tonight, and we really wanna put this thing to bed. We can't hold this thing over any longer. So you wanna just give bullet points to it? Again, we're not gonna have time to sit here and read it.
Let them submit, still for the record.
Yeah, certainly submit it, of course, but,
That's the sole purpose that I'm providing it to the board this evening. For your
Okay.
consideration, what you do with it, that is up to you.
okay.
Thank you.
All right, do you guys have anything further?
I am very surprised for the boys from the VFW. Because when he raised his hands up, he need to say true and the only true. We never argument with nobody. My wife work in the school with some members from there, and we always share very friendly, and we taking our beers together. And these boys I never see over there.
Mr.
is-
Kodai, you have to address us.
No, but when
And
he
the way
said-
this is going
and-
right now, this is
Okay.
going to a fight
And-
between people
and-
that we're
I
not
don't
here
want to fight to
argue
nobody.
And
Uh,
to judge.
Just to
and
make
be
a story
jury of,
short.
Okay?
Where Mr. Barelli lose the property, the lawsuit with us, he told to the neighbors, VFW, you can build the side docks. I have picture right there. And if you look before 2018, 19, he have only strips straight to the lake. After that, he built another 3 strips side just to block me because Mr. Barelli told me I am not interested for the lake. I am only interested on the property of the lot. And I am very surprised how she never shame.
But this does not have anything to do
No,
with
he
what
blocked
you're
me the
trying to
area.
achieve here.
He blocked me my area. If you look frontage, he need to be straight. And the third part, those pictures, he's supposed to be shame of them to bring over here to show everybody how he tried to steal my lot. And he maybe if you look details, you can see the
You're
2
getting
by
into
4.
personal matters, which we're not here to adjudicate.
No, it's important. Can I just say something very important?
I know you're very passionate, and I feel sorry for your situation. However, we have a certain set of facts in front of us, and that's only what we're going to judge upon.
And Mr. Chairman, the last point that I will make, and I think it will be a little bit more concise than Mr. Kotaj, is that he mentions this, quote, stealing of the property. In the lawsuit, if you were to look it up through the electronic filing system, you will see that the counterclaim against my client was for adverse possession, and that the property was treated as if it was owned by the Barilli Stern family. That was their allegation. The matter settled. They have an easement over my client's property. They have the right to utilize my client's property, and we're merely seeking to use the property that we own and pay taxes
And that's settled and has no
on.
bearing, as far as I'm concerned, on what's in front of us right now.
Understood.
Interpretation. So,
And never can do maintenance in generator if you no go to my property. Yes, generator sit in her property, but it's all the way in the corner. That is number one. And number two, it's special for the lake. If you want to maintain the house, even that too. And the main thing I forget, for that lot, with lawyer, architect for the dock, and survey, I spent $30,000. My money, and I have in the deed from the first day I buy the house. In Albanian says one words, make the
Say it
knife
again.
both sides.
it's unfortunate.
And you can do
Situation.
whatever. I respect you guys.
Okay.
Thank you very much, Mr.
All
Chairman.
right, guys. Thank you. I'm going to look for a motion to close the public hearing on this
So
application.
moved.
Do I have a second?
Second.
All in favor?
Aye.
Okay, application number 3.
Yes. Festo.
Michael J. Festo, variation of section 156-101 and 156-47A1, seeking a use variance for permission to encroach upon a front and rear setback with garage and expand non-conforming use to family. The property is located at 247 Bucks Hollow Road, Mahopac, New York, tax map 75.16-2-1. Good evening.
Good evening. How are you? Nice to see you again.
Good, you're back.
Happy New Year. Round 2.
You had submitted a letter, actually, we have a new procedure here.
Swear him first.
Yeah, I'm going to swear you in. Name and name and address?
Michael Festo at 247 Bucks Hollow Road, Mahopac, New York.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Okay. Each application now has to be carried under the short environmental assessment form. So I'm going to read these questions to the board members, and we have to decide on if it's if it may occur or not.
Yeah, just for the record, before we start, I do have a signed copy of the hardship letter here. What you guys got is all copies, so.
Okay,
Okay.
understood.
I'm just-
If you want to
just saying.
submit that for the
Is
record.
that the letter from John Malloy that we got today?
Yes.
January
I submitted
22nd.
it yesterday, yes.
Yesterday. All right, so, part 2 is to be completed, so we're claiming lead agency here. So the first question is, will the proposed action create a material conflict? Greg, am I right? We have to do this before we hear the case, correct? Correct. Okay. And as presume everyone had a chance to look at this, and actually it's a holdover, so of course, most of us did.
Right.
So will the proposed action create a material conflict with an adopted land use plan or zoning regulations? And it's either no or small impact may occur, or the next choice is moderate to large impact may occur. So will the proposed action create a material conflict with an adopted land use plan or zoning regulation? Yes, it's regulation because they're seeking a variance, so,
Right.
Apologies, I'm thinking,
right? So do we all agree that
Yes.
no or small impact may occur?
yes.
Number 2, will the proposed action result in a change in the use of intensity or use of the land?
I thought it was a use variance,
No.
because it was pre-existing
It's a
non-conforming.
use
Oh, it's
variance.
an right, we want to discuss this because we
Yes.
wanted them there, because it's expansion.
But because it's a non-conforming, you're stuck with use standards. That's why we're doing the secret.
Greg, can't hear you. Can you speak to the
Their
mic?
area, it's an area variance, but because it's a non-conformity, you're stuck with the use criteria because it's being expanded. And you can wait to do it until you hear the whole application and make a determination before you decide if you want. So if you
Which
want
is,
to
I
do
think,
it
what we
now-
were hung up on last month, Greg, is it
Yeah,
like,
fair enough.
which criteria do we need to hold this by? Gotcha.
Well, that's two things. Okay, first is that if there's use relief that's either sought or has to be applied, you need to make the secret determination. But you can do it after the application, I apologize. So you can hear the application in full, and then when you
All
decide.
right, why don't we do that, because that'll have bearing on
Because I
some
was
of
gonna
these
say, that's
questions.
gonna drive the question.
Fair enough. You want to do the secret on a completed presentation.
Yeah.
And this is use and area, just so everybody
Use and area.
there is an area concept also that they're too close to that front yard.
Okay.
Even though it's, okay. All right.
All right, so, I think we had some questions about the size of the garage and how
Yes.
big it was and what really the need was for here. We gave you an opportunity to rethink that, I believe, if I recall, to make maybe a little smaller, lessen the need of the variance, and I don't think that happened. Correct me if
This
I'm wrong.
is,
you guys have
well,
any
it's 33 by 40,
recollection?
right,
Yes, the
Michael?
size stayed the exact same.
Exact same.
The only thing that changed here is the driveway. The original plan was to come off the Route 6 end onto Bucks Hollow by the bike path.
Right.
That has changed now. It's coming in off of Bucks Hollow, going, I think, east towards the stop sign there on the corner.
Of the,
So it doesn't impact anything on the Route 6 side of Bucks Hollow. So that has completely changed. The size did stay the exact same, though.
So, Michael, the garage was a three-car garage,
Yes, it is currently a three-car garage, yes.
and then there was another room and and a loft,
There's no room. It's second floor,
second floor,
and it's just storage. It's going to be used for storage.
the second floor.
Correct. The first floor is a three-car garage with the staircase going up to the second floor, which is going to be used for storage.
And did you look at with the architect to scale it down a bit? You know, you're 8.83 feet away from your back. Was there any way you could bring that in, or?
I mean, the big point is it's almost the same square footage and footprint as the house. I mean, if you,
It's large.
yeah, if you took the square footage of the house, it's got many jogs and ebbs and flows here, but it looks about the same footprint.
Right, but if we
So-
jog it back, I mean, how many feet are we talking? Maybe 5 feet?
Look,
It's really
I-
not going to make much of
I
a
have a
difference.
bigger concern here based on the letter from your lawyer. You guys, it says you represent your business, you're an electrician.
No. That's incorrect. You read it wrong.
I
That
represent
is
the
my-
business North County Electric and North County Homes
Yeah,
as well.
correct, that's my father,
Okay,
which is stated
Yeah.
in that letter.
okay. maybe I
He
read-
also represents my father.
Yeah, he also represents
Yes.
your father.
Correct.
Okay. Oh, their business.
And Uncle
Yes.
Joe. Okay. So I was just concerned that this might be used in a commercial sense, that.
This will not.
Storing.
This will not be used in a
equipment and
commercial sense at all,
tools,
no.
material. Okay. I mean, again, it's really, it's a large footprint, and it's very close to the lot line. I mean, if this thing was scaled down, I think we can
But
We
even
can
still, John, we have
swallow
to,
this a little better.
we have to use the use variance guidelines, the criteria, incapable of earning a reasonable return. I don't see that. The financials aren't there for it. He paid a certain amount, and he's still gonna get rent. He could get rent off of 2 of them. I'm not seeing the incapable of return.
That is incorrect. I'll be getting rent off of 1 unit.
Well, then you're
I'm
gonna be
moving
living
into
in
the,
one. Well, most people
one of the
don't.
units.
Most people live in a house and they don't get a rent at all. So you're getting more than most people, you
Okay.
know? I live in a single-family house. I don't get rent. So you're doing better than I am.
But maybe down the road, maybe I can make it a single-family home and just I can live there myself. So I could have plans of that
That's
too.
not the situation
Time out.
is now.
If you make this an accessory apartment and you live there, You don't need the use concept. So if you put a condition that you will live in this house, or the owner will, then that whole concept goes away. You don't need the use variance anymore. Because you now have an accessory apartment which is allowed in that zoning district.
That is the plan. So this is my reason for building this garage. I'm gonna be moving into one of the units, maybe the entire house down the road. But right now, it's gonna be one of the units for sure within the next year, once the first floor tenants, leases up.
So the only way you can do that is you have to actually legally make it an accessory apartment. So you got a one-family dwelling with an accessory apartment, and then you don't need the use criteria. Then it's just the area, and again, this is up to you guys for the area. That's,
You're still under pretty
Correct.
tight constraints for the area variance requirements.
but anybody's allowed to have an accessory apartment if you have owner occupancy, of course.
I am in your limits, though, of max building coverage, though. I mean, if you look at my table on the bottom right, table of zoning data, which is,
But also due to the size of the footprint, you're encroaching into the setbacks.
Correct,
That's
but-
why your variance
That's why
is
you're
more
here.
extreme than,
okay.
so if the garage were smaller, we can split hairs here, you know what I mean?
But you would have to live in this house. The person has to live in it. So if, it has to be owner occupied. So let's just say you live there, and 5 years down the road, you have a family and you want to go live somewhere else. Then we have a problem. You have to live there. The person has to live there.
Okay, well, that is my plan to move into the house. So within, when this tenant's lease is up, I plan on moving into the home.
That's not the situation now. So
Yeah, so
you
we have
might
to play
want
by
to
the
just
rules
dismiss
now.
this for now and come back at a later time under that
I
criteria.
don't think
but-
that's necessary.
I'm looking at,
Well, the law tells us it's necessary, that's the problem.
Okay.
even,
Today, you don't live in the house, so because you don't live in the house today, it's a use variance. If you lived in the house, the game would be different.
Okay, so let's keep it as a use variance then.
well,
Then you
Not
have
in
to
your
meet
best
all
interest,
that.
I'm gonna tell you that right now.
either way, I don't see it because
Well, right now, it's a
It's
use variance,
self-created.
so let's treat it that way. It's not,
This- this is
I'm
just-
not changing it, it's a use variance right now.
All right, you're not changing it, it's a use variance.
Right.
Okay. With the use variance, you have to prove all of the criteria. There's 4 criteria, and you have to prove all 4.
I'll read them
It's-
out to you. Number one is incapable of earning a reasonable return if used for any of the allowable uses. Dollar amounts must be shown. I don't think you've shown dollar amounts to that.
The letter does show dollar amounts, but
To
to me,
a
it's
certain degree.
inconsequential
Because
because
he doesn't live there.
it's not.
They're not part of
Exactly. The
building
garage.
the garage. If it was
100%.
legalizing,
Something that was
Apartment
existing
or
would be a different
something.
story.
Right.
That's right.
Number two, the property is affected by unique or at least highly uncommon circumstances. Number three, will not alter the essential character of the neighborhood. It will because it's such a large footprinted and second-story garage.
Can I just note there really quick, I didn't have an opposition last time, and I still don't.
That's.
I had
regardless.
neighbors here last time, they were here, there was a lady and a gentleman, and they met me outside, and they actually were with this plan. They were on board, I don't know why they didn't say anything, because they had no opposition, which is understandable.
We don't have anything to submit for the record, there's no letter or
Okay.
in support.
Yeah,
Well,
you
I
have a
can,
letter-
I can get that
You have a
easily,
letter
I'm
from
sure.
Zigger Johnson, he's across the street from you.
I do not have a letter from,
Billborg Zigger Johnson.
I do not.
It doesn't matter because in the area variance, you still have the dollars and cent problem and the self-creation problem. So you have to comply to all 4. You don't have 2 of them right off the top.
Number four is that it's not self-created, and obviously this is, you're creating it. So, under town law, all 4 of those criteria have to be met. Whereas if it's an area variance, 3 out of 5, if they're satisfied, generally depending on how the board is thinking that night and the criteria. Each project is judged on its own merits, own circumstances. You're in a tight lot, you have a tight situation, that's why you're encroaching onto the building setback. That's why we're trying to help you.
This
You might
lot-
want, if you need this, we can make it smaller and less encroaching. It's kind of where I was leading to you last time.
What
you were
is
in front
that,
of us.
though? What is smaller? I
But you
mean,
still have to live there.
okay. So,
That's, he's just
That's a
stated,
use variance.
he's trying to go with the use variance because he doesn't live there, so he's got no choice. So you have to meet all 4 of these criteria. And Rose just painted it out to you, you're not meeting them. So you may want to hold this back or dismiss this until you do live there. That's your choice.
If you come back with an area, we just take everything into consideration with your neighbors and letters and support.
Even since,
It's
Right?
easier to
We
work.
all
I
know
don't-
the
I don't
property,
think
we
that is
visited it,
necessary.
We know, we're familiar with it,
well,
so.
then, we can vote on it. We'll vote on it, and you could,
It's not, I understand where you're trying to go with this, but you have to understand, state law dictates what we can and can't do here, right? If this board deems that you didn't meet the financial hardship, let's just argue with that one, because that's the one where I'm hung up on. You're done.
Yeah.
There's nothing you can do. That's state law. So what we're trying to tell you is, until you get into that house, you're under the criteria of use variance. We're done.
Okay, so the financial hardship you guys disagree with, you guys didn't, you didn't think I meant that?
It's not applicable. That's the problem. At least in my mind. I'm one board member, but in my mind, it's not
I
applicable.
think most people are kind of leaning towards that.
I mean, guys, the existing property right now is heavily wooded. It's a blind corner coming around. This would be an upgrade to the area
Mr.
and the
Festo,
community.
I understand what you're trying to argue.
Have you ever driven through there, coming off of Route 6, coming down towards that, there's not even a stop sign on that corner where the tip is.
What I'm trying to tell
It's-
you is, this isn't an arbitrary decision. This is state law. This is the criteria where we're bound as a board to act upon. If you fail to meet all four criteria, we cannot allow you to have that variance, period. This isn't arbitrary. This is law. I can't help you.
Look, I think we gave you recommendations to seek counsel or, further advice on this based on, read back the minutes, or you can rewatch this and kind of determine what we're getting at. So we can hold this over one more time. I wouldn't go beyond one more month, but if you want to proceed, we'll proceed.
I definitely want to proceed.
Under use variance criteria.
I would wait until you move in.
I want to just see, you guys keep saying how much to make it smaller. What's smaller? I mean, this is 33 by 40 right now. What is smaller?
how big is your lot again? A quarter acre?
Says it, about a half an acre.
A half an acre, so you.
Yes.
My whole thinking was, you already have two garage spaces. Now you want 3 more garage spaces. I don't know on a half acre why you would need 5 garage spaces. And it doesn't work for me.
Okay, so those 2 garage spaces right now are very small. You can't even get a small car in there. Okay, second of all, like last meeting, I said I have a couple cars and I'm paying for storage right now. We went over this last meeting. And that is a plan to bring the cars into this garage, which is why I need a 3-car garage. And then there's more storage on top, which is gonna be all dry storage.
Properties aren't always large enough to do certain things. If you want 5 garage spaces, maybe you need to have a house somewhere else. This lot is not a good lot.
conducive
Like
to
you,
it.
like you said, there's that turn there, and your building may very well obstruct the view coming around.
It's not the building. It's not the building at all. The building is, if you looked at it, it's probably about a quarter of an acre up into from the corner. You know what I mean?
Yeah.
So like when you're driving down towards the tip to the corner, there's no stop sign, like I said, and you're making a left going towards my house, there's no visual at all. It's completely blocked. There's trees, there's brush, you cannot see anything. And there's no stop sign coming from the other way, the opposite way.
We
coming-
understand the improvement that you're
There was
making.
actually an accident there last week,
I'm
right
sure-
there.
I'm sure, there's no doubt in my mind.
And I'm sure there's many others that I haven't even heard
So,
about.
look, I'm going to end this. It's either you want to proceed with the use variance, or do you want to go back and get advice, and we'll hold this over.
I
one
would
more
like to
time.
hear what you have to say. I mean, with
You're
making
hearing
it-
what we
With
said.
making it smaller.
You're making this a large, it's a 2-story structure.
What is smaller?
Next to, if you had a 1-story, it'd be different. It's encroaching on the one property side. You can move this thing inboard more. We're not going to sit here and redesign it. You want to go back and rethink it, you consult with an architect, a lawyer.
I got you. But
feel
it's
free.
33
If
by
not,
40.
we'll proceed with, as a use variance criteria.
Okay, cool.
You got to show, like, this, how is it not self-created?
I just want to know here, before we proceed with any more questions, what are you proposing? You keep saying smaller. What is smaller? I mean, a 33
What
by
is
40.
smaller is nothing,
It's not.
Okay,
right?
Realistic-
You know, when it comes down to it.
But John, size isn't gonna make a difference here because we're still under use.
Use
Under a
variance.
use
Until he gets
variance.
the area,
Right.
we
Yeah, I
can't do
understand
anything.
You have to live there.
We can't do
We can't
anything
do
until,
anything.
I'm just saying.
last everyone told me, all I need is a financial hardship. And
You have,
You have to show
But you didn't
that.
show it.
you
I
have to
provided
do
all the
it.
financials here. It's a
does-
negative cash flow. I mean, go to the second page. You can see everything.
Yes, but
With
it-
the intention
it's
of living
not
there eventually. You
related
don't live there now.
to- It's not related to the use that you're proposing here. That's where this goes sideways.
That's right.
Maybe we should just close this hearing.
I
Yep.
think what you have
All
to
right,
do is you have
I guess
to,
we should just close the hearing.
What?
Vote on it.
I just think you have to prove that using it as a two-family house, that you need those 3-car garages to make a profit, if you want to go with a financial route.
But the garages have to
But
be part of the
but it sounds
profit
like the
equation.
garage is a separate issue from the rental unit being profitable. So it's kind of like two separate things.
It's cart before the horse.
It is.
All right.
So, all right, we're gonna proceed, or do you wanna hold over? Last time I'm asking,
Hold over.
okay? Greg, do we still have to read the short environmental? Or we do that next month? Next month, okay. I'll look for a motion to hold this over.
So moved.
Do I have a second?
Second.
All in favor?
Aye.
Okay, I'm gonna, just one more time, that's it, all right? Please, because we can't keep holding cases over and over.
Thank you.
Hold on, I got my system here. All right, application Vukaj. I think this is Willie, right?
Is it Willie?
Is that Willie? Let's see.
Willie couldn't make it.
Yes.
Yeah, we got a letter that the representative is not feeling well, so we are gonna
Motion to hold
give
over.
her courtesy of holding this over. Do I have a second?
Second.
All in favor?
Aye.
Okay, so that's held over. All right, new applications.
A new one. Holy smokes.
Application of Norman LLC, Norman Sass, for a variation of section 156-15, seeking an area variance for permission to construct a second-floor addition. Property is located at 36 Lillian Road, Mahopac, New York. Tax map 64.11-1-37. So the code requires or allows 40 feet for frontage. What's provided is 36.32 feet on Kirk Lake Drive, and a variance required of 3.68 feet. Good evening.
Good evening. I'm Donald Zeller. I'm the architect for Norman and Minnie Sass.
Okay. Will you raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Bring us through it.
Okay, so we're seeking a variance to build a second-story addition over the front part of the house. As you can see, 3.6 feet of it projects over the setback line.
So that footprint is existing now, right? So
Yes.
Just because of the nature of going up?
Yes, yeah, they want
the
to
need
maintain
for
the same
variance.
footprint. And, you know, the second story addition, if it were built at the setback line, would look awkward. And, you know, and the setback line doesn't go like perfectly parallel with the house, so we just want to be able to maintain the footprint of that, this front projection of this house.
As well as the foundation for strength,
Correct.
obviously structurally, okay?
Yeah.
You talk to your neighbors, or their neighbors? No opposition
No,
to
no, I
this?
have not.
All right, there's no other property you can buy to bring it into conformance. Obviously, the land is owned on that side by someone else.
And it's a corner lot.
Oh, okay, so you got two frontages.
Correct. Yeah.
All right, let's start down this way. Will, any questions or comments?
No questions.
Bill?
No.
No questions.
No questions?
Carlos, John?
I'm very familiar with that property. It's really a great piece of property at Kirk and Lillian there.
It is.
And it looks really good, the design. It's a
Thank
nice
you.
house to begin with.
All right, anybody in the public wish to speak on this application? Questions or comments? Okay, I'll look for a motion to close the hearing.
So moved.
Second. All in favor?
Aye.
Okay, thank you, good luck.
Thank you very much.
All right, application number 6, P&R Estate Corp., for a variation of section 156.15, seeking a use and area variance for permission to legalize a 4-family structure, formerly 2 apartments and 2 commercial, and the property is located at 122 Glenida Avenue, Carmel, New York, and it's tax map 44.13-2-68. So there's a lot of them here. The code requires or allows for lot area 40,000 square foot. What's provided is 17,360, so a variance required of 22,640 square feet is being sought. Lot width is 200 feet. What's provided is 147 feet, so a variance of 53 feet is required. Lot depth of 200 feet. What's existing is 185 feet, so 15 feet is needed. Front yard is 40 feet, 22.8 feet exist, so 17.2 feet is being sought. Rear yard is 30 feet requirements. What's existing is 23.1 feet, so 6.9 feet is required. Code calls for building area of 5,000 square feet. What's existing is 3,200 square feet, so a variance of 1,800 square feet is being sought. And the use variance is mixed use, and what's being sought is 4-family. Okay? It's a lot going on there. You are?
Hopefully, we'll be able to explain it. I am Robert Sherwood, landscape architect for the project and the site planner, and been helping the Peter and Robert, the owners of the property.
What's your address?
My address is 44 Riverside Road, San Diego, Connecticut.
Okay, raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thanks.
So again, Robert Sherwood, landscape architect, been helping the owners of the property, Peter and Robert, navigate through. We've obviously gone through planning board. They're secret lead agency. We've been also to the Wetlands Board for some approvals, and the final step of our process is to go to you all to seek the various variances that are requested, and then back to the planning board for approval of the entire property. Peter and Robert bought the property 20-plus years ago, 24, 25 years ago. They thought it was a perfect building for them. They have a small painting contracting business, and they thought it was great that they could use the commercial spaces for their own office, which they did for some years. They found a better building locally as well. They own in town. They bought that because it provided them some more dry storage. And so when they moved out of the building, they had a small office space, really 2 small office spaces kind of for rent, and 2 apartments. The apartments were fully rented. They have a backlog of people that want to rent from them, including their own employees. And it became an issue where the commercial spaces fell vacant for a couple of years. And so the determination was to convert those commercial spaces to an apartment because they knew they were readily available and easy to rent. So that's where the 4-family came from, out of a mixed-use genre building. When they did any of the renovations, they did not expand the building in any footprint-wise, make any of these area variances any more non-conforming. The building has stood that way probably since it was built.
So they went and built these?
This was all inside the building.
So they were existing as apartments?
There was 2 existing apartments
I get
and
that.
2 kind of office space
Commercial
apartments that they had utilized as their office. And when they vacated, no one wanted to rent small office space.
So what I'm saying is they already converted them to usable
Yes.
rental
Yes.
units without, okay.
Yes. So, therefore, it came up a few years ago that obviously it's non-conforming. We need to get an approval. We've gone through the planning board. The planning board, we have worked diligently with and have come up with a great resource of trying to make the entire streetscape look better. Currently, 122 Gonida has face-in parking on the building. We've worked with the state to get a DOT permit for a curb cut. We worked with wetlands and the planning board to create a parking lot that's now fully on the property. So there will be no more front-loaded parking on Glenida, which we feel and the planning board feels is a fantastic addition for the town. Other subtle things going on with the building itself, we're going to enhance the building, try to clean it up more and put shutters on it to give it more of that residential feel so it blends into the rest of the neighborhood.
So they had mixed use, did they try to rent to any?
They did, and it fell, nobody was renting a small office space, so.
Right.
And again, it's what type of office, the parking is kind of full in front, there's.
Yeah, it's not conducive to.
It's not very conducive for, a commercial space. It worked great for them when they were.
All right, so in my mind, this is going back to a better use for a residential area.
We think so, yes.
It's more restrictive. We always said that residential's more restrictive than commercial, right?
Not
Residential.
necessarily. It depends. The mixed use is not allowed.
I was gonna say,
Okay,
that's
so
the thing that threw me off.
end of the day, you're gonna have 4 families there, that's it, correct?
Yes.
All right, so he's getting rid of the mixed use, so it's becoming more restrictive. Or that's what you've determined in the past. That's something you should be determining now. And if that's the case, the use variance is a no-brainer. It's not a difficult one, because it's becoming
Right.
more restrictive. It says in the code that less intensive use, thank you.
Right.
The code says that they can change to another use, provided it's less intensive, blah, 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 and that's where you're allowed to get it from that section 156, I think it's 41 or whatever.
But it's still a use variance?
But again, this is not the use variance that they're going in the right direction.
They're restricted.
They're getting rid of the mixed use that's not permitted.
So wouldn't this be now permitted? Isn't it more permitted now, or it's still not permitted?
Yes. And that's why I said,
If it's permitted now, then why is it a use variance?
it's a less intensive use. It's not permitted. A 4-family is not permitted.
Four-family is not permitted.
But it's not a mixed anymore, which is really not permitted.
Gotcha.
That's better. The trick of zoning is to get rid of those mixed-use buildings unless they're permitted in the zone, which I think we're actually doing in the next zoning code, so.
That's later.
Is that like a residential zone, Mike? Is that a
That is commercial there.
It's commercial.
Oh, gotcha, that's why it's use variance.
And there's no change to the footprints of any of these buildings?
No, currently, if we look at the site plan, the building, there's a front porch on it. When they purchased the building, the front porch was there. When they purchased it, this section of the building was one of the commercial office spaces. So at one point, that was filled in, but no, there's no expansion.
So all of these
Are
are
existing
existing.
when they purchased the property. And the property is kind of this
Yeah.
J-shape. I believe
And it's tight
when they
up there.
subdivided this, it happened years ago, they must have made this contrived lot line to try to make this building conforming, which this one, then the rear yard setback wasn't right, the size of the lot, et cetera.
Yeah.
Okay.
Guys,
Board members
156.
have any other questions, comments?
Go ahead.
There's a specific section, you can read it, in your
Thanks.
code, when it goes, when it goes from one non-conforming use to another, that gets you out of the standard use variance criteria.
Perfect.
Because your own code permits for it tries to allow for the elimination of non-conforming uses, even if it's in phases, so you can go.
So then, we no longer need the.
Go ahead.
Except as provided herein, you shall not be expanded or changed, blah, blah, blah. Unless they're changed to another non-conforming use without approval from the Board of Appeals, and then only to a use which, in the opinion of the board, is of more restricted nature.
So that's, if your determination is that the proposed use by this variance is more restrictive in nature, then you wouldn't have to go through, you're giving them relief under that section, rather than the standard use variance criteria where it's from a non-conforming use, from a conforming to a non-conforming. Follow?
Learned something.
So you got, is there any room for a playground back there, or you got any green space?
Currently, well, we're gonna have a lot more green space in the front, we do have a little thing in the back, there is some in the backyard as well. Currently, I don't believe there's any play spaces out there.
Okay.
There is a patio on the side over here that exists, maybe we could if they needed to, they could put something in.
No further questions?
Board, on this side, any questions, comments? No. All right, any public input on this application? I'll look for a motion to close the hearing.
So moved.
Do I have a second?
Second.
All in favor?
Aye.
Thank you, sir.
Thank you.
Good luck. Number 7, application of AFC Urgent Care for variation of section 156.41C2, seeking an area variance for permission to extend a sign larger than 40 square feet. Property is located at 1844-1936, Route 6, Carmel, New York, and it's tax map 55.11-1-4. The code allows or requires 40 square feet. What's being provided is 78.8 square feet, so a variance is required of 38.8 square feet. Good evening, folks.
Good evening, everyone.
You're both going to be speaking.
I'm Seema Gupta.
Okay, state your name and address for the record.
Seema Gupta. We live in Yorktown, 3091 Chen Court, Yorktown Heights, New York, 10598.
And you?
The address.
Okay, swear to tell, raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
And if you're both going to speak, you can pick up that microphone and speak on there as well. Okay. Go ahead, bring us through your
Hi, everyone.
case.
Yeah. So we are a new tenant at the Putnam Plaza. We recently leased the space, and we are asking for the variance for the signage. Being as an urgent care, the signage is the most important aspect for the visibility purpose.
Sure.
So the frontage allows, it's like 120 not square feet, but 120 feet. And we are asking for the biggest which can fit in it. And being as AFC is a part of a franchise, so we do have a set signage. So we cannot alter the signage, whatever they are providing us, we have to stick with that. So the biggest, as per the franchise requirement, is 78.80 square feet, which perfectly fits in there with the 120 feet of the frontage. Space we leased is 3,200 square feet. And this is it's the simple, like we just need the visibility because that's the biggest, and for the business point of view, visibility is the greatest aspect for any urgent care. So we are asking for the largest we can fit in there, which does not go beyond the proportions in there, is 78.80 square feet.
Yeah.
So that's what we are requesting.
Yeah, it's brand new. You know, it
Yes.
looks good over there. And you wedge between the dollar store and I think the Szechuan house.
Right, yeah, we are at the
them
previous
up
dress
here.
barn space, and it was
Yeah.
subdivided right next to the Starbucks. The entire plaza does have a different sizes of the signage in there as per the requirement, but we just are requesting the 78.80, which would be really great for us.
The size of the lettering, is it the same size as is it fairly consistent, the height of
Yeah.
the?
Yes, the only thing is, in our requirement from the franchise system, the bandage sign which you see in the signage is taking up a lot of square feet in there, and whereas the channel letters are not that big, but that's the kind of it says the Carmel Urgent Care, but
So I was going to ask you, this is not the same exact.
it's not the same exact,
It's
because I wasn't able
representative-
to put
similar
the.
to it, but
Yes,
it's-
it's just the bandage sign. There would be another page.
So that's
Yes,
the
there
one
you go. Yeah. Yeah.
AFC.
But this is representative of the length of it?
Yes,
And
exactly.
the height?
And the height, yeah.
Okay. Which, in my opinion, feels to be pretty well proportioned.
Yes,
for
it's
that
pretty well
fa-
proportioned
facade.
in there.
The problem
You
I
guys
have
are
is they,
bigger tenant space there as well,
Yes,
so
we do,
it almost-
we do.
It's,
Yeah.
it's because the Band-Aid
that
expanded.
Band-Aid knocks a lot of, it's the
Yeah, that's
smallest
taking up
rectangle
the
to
more.
encompass, so.
Yeah, exactly.
No,
We
I
went
see
over
what it
this.
is. As soon as you said it, I was like.
Yeah, we went over this, we were trying to figure out
I know,
how to make it
yeah.
work without doing the Band-Aids. I said,
No,
just get
so
what you
the
want so
franchise
that you-
system won't even allow us to go without the Band-Aids because it's the set, their
Because it's their
signage.
logo, it's like
It's
having
their
your
logo.
arches if you're McDonald's or whatever. I get it.
Absolutely,
I
yeah.
get it.
Yeah.
Is anything going on this sign?
No, just the pylon sign. It's going to be the urgent care only
Okay,
underneath.
and it's gonna be in this one
That
little.
blank
Yeah,
spot,
blank spot
Top
right
spot.
underneath, yep.
Yeah, so that's.
What does AFC mean?
American Family Care.
Okay.
There's one in Yorktown.
Yeah, it's one in Yorktown. That's owned by us too.
Oh, okay.
Right in the BJ's Plaza. So,
Yeah, right.
Yeah, right. It's the exact same signage, but the smaller, of course. The building is big over there.
Thank you guys for being available when our doctors aren't.
Yeah, we are very excited to be in Carmel, yeah.
It's every doctor now.
Yeah,
Oh,
right.
Oh, you need an appointment? Yeah, 2 months from now, sorry.
All right, exactly.
All right, board members, any other questions or
No
comments?
questions.
Any input from the public on this application? I'll look for a motion to close the hearing.
So moved.
Second. Second, all in favor?
Aye.
Thank you, guys.
Thank you, everyone.
Good luck to
Thank
you.
you.
Thank you so much. Thank you.
Yes, certainly invoiced. All right, last application is for Robert Latiwick for variation of section 156-405.2B1, seeking an area variance for permission to retain accessory apartment. The property is located at 1350 Route 6, Carmel, New York, and is tax map 54.15-1-17. The code requires or allows the structure to be existing from 12198, and what's being provided is a structure or the garage being built after 12198. And the variance allows, or variance required is to allow accessory apartment and garage built after 12198. Good evening.
Good evening, John Carell for Mr. Latowick.
Address?
121 Cushman Road in Patterson.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you, sir.
It's great to be last. This is an existing garage with a store, it previously had a storage space above it, which has a CO, right, Mike? They had a CO for that garage with a storage space.
That's correct.
And over the years, more recently, I guess, they constructed a one-bedroom apartment up in the storage space for their use by their children and their parents if necessary. And we're here for, I guess, an area variance.
Okay.
Oh, and we've been with the health department. They made us test out the expansion area of the septic system, and the only thing we have to do is put in a 500-gallon septic tank because the health department changed their regulations so that a four-bedroom house or a three-bedroom house can now be a four-bedroom house. So we're all set with the health department after we get hopefully your
So that's
variance.
a separate system from the main house then?
The garage apartment has water and sewer from the main house.
Okay.
And the main house has a septic system in the backyard, and, yes.
Interesting. All right. Any questions from the board? John? Rose?
Why is this coming up now? Are they putting it on the market, or?
It was constructed, the apartment was constructed illegally because it was approved for a storage space, and now it's an apartment. The man lives in the house, has lived in the house for a long time. But the building department violated him, and in order to fix the violation, we need variance from you guys, and we need health department approval.
You have a fence in the front.
Big fence.
Big fence, 6-foot fence?
Probably.
Probably. That's
I didn't know
something that
that.
has to, you need a variance for, I think. 6-foot fence along Route 6. You're
If
gonna
it's
need a
less than-
variance for.
It can't be 6 feet until it reaches the front of the house, then it can be 6 feet in the backyard.
We're gonna add that to the variances.
Well,
Yeah.
I mean, it's,
you have to renotice it, though.
That's the problem.
It's another one, or renotice it.
I can go measure it. I'll go check it. I don't know what's there, honestly. I didn't. Dennis wrote this, and Jack came to me to legalize it, and the code says you're allowed to do an accessory apartment in a detached structure if the structure was existing when the code was written, which is 1998, so obviously it wasn't there yet.
Okay. Yeah, I think it's higher than 4 feet, the fence.
Oh, it's definitely higher than 4 feet.
So then you definitely need a variance
Oh, okay.
for that.
So I guess we'll be coming back.
All right. we'll have to hold this over, and then, unless it's accounted for, but you would have known that, or would the client have known that?
What if they lower it?
Or if they lower it. I can ask.
Yeah, why don't
them-
you make it a condition that he either lowers it or comes back and legalizes it, so that this way you can decide on this part of it?
That would be nice.
Yep.
Because the guy may say, well, just take it down to 4 feet, and then we didn't hold it over a month for no reason.
Or if they want to keep it where it is, they're gonna have to come back and fight it.
Okay.
They're gonna have to come back and apply for the fence separately.
Or lower it.
Or lower it.
If it's over 4, which I believe, Jack, that's you.
Yeah, it's definitely over 4.
Okay.
Okay.
All right, any more comments, questions from the board?
If we condition it, then they would have to pay for another building another permit, right?
Not permit variance.
They would have to pay for another variance. Where if we just hold it over, they won't have to pay.
Maybe they just add it to it, maybe just
Well,
amend
they'd
it.
still have to advertise.
Yeah, have to re-advertise it.
They still have to re-advertise it.
Yeah, It's up to Mike. Whatever Mike says.
It's not in the file. It's 13.
Yeah, he wouldn't need the variance if he makes it legal.
Right, if he drops it down to 4 feet.
That's right.
But does he really want to cut it back 4 feet?
What kind of fence is it? Is it feasible?
I
White
think
vinyl
it's a
fence.
white vinyl.
White
fence.
vinyl?
White vinyl.
Yeah,
Very
but
tough to cut that
he
with a
probably-
circular saw.
He would probably just, if he's gonna reduce it, if he's gonna reduce it, he would just put up a new fence. I think, well, because he's got, what about the gate? He's got a gate there that, automatic gate, which, I'm pretty sure that gate's over 6 feet, or
Then he
4
need-
feet.
then he
4
needs a-
4 feet for the gate too?
Everything.
That's a problem, then we're gonna have to come back, I think.
Why don't you hold it over then?
Yeah.
Yeah, hold it over.
Let's do that.
We'll hold that over. Hold over.
Can of worms?
3 homos.
Can of
4
worms?
homos.
Thank you.
All right, there's no, well, we're gonna hold it over, so, look for a motion to hold this over.
So moved.
Do I have a second?
Second?
All in favor?
Aye.
Thanks, Jack.
See you next month.
Take care, Jack.
Okay.
Got a holdovers.
Can't clear out our own.
Hate that. I hate that.
I do too.
Yeah, because then you have to amend it and
Finalized it.
then you have to amend
All right, I'll remind everybody, there's no input at this point. All the public, all the hearings have been closed. Go back to the beginning here.
One is held over.
All right, number 1 is held over
Cotage.
already. Number 1,
Number one's held
Altero.
over.
All right, no, application
Willie's
number 2, Cotage. I'll look for
Hopefully
a motion or interpretation affirmation, if that's the right term.
Motion to deny, when you go over all of the criteria.
Well, hold on.
Rose,
we
what
need
are you
to-
denying?
Hold on,
There's
I
two
need a second
ads.
before we can discuss, guys. Do I have a second?
Well, hold on. She,
interpretation or the variance?
correct, that's what we need to know.
Interpretation.
Interpretation of the variance.
The variance.
You're going with the variance first, not the
I'll go with the
interpret-
variance first.
No, I
No,
think we need to do the
we have to go with the
interpretation.
interpretation first.
All right. Motion to deny the interpretation.
All right, do we have a second on that?
No second?
Second. I second that.
Okay, discussion.
The interpretation is that because it's on the same deed, that it's considered part of the property. It's considered a parcel improved by, it's part of the residential unit. Because East Lake Boulevard goes across, I just don't see how you could interpret that that's correct, because there are 4 different lots there, and it just doesn't seem that it would be feasible.
John,
The
you wanna answer
intent
that?
of the statute, I don't know if the intent of the statute was to have a street intersecting it.
Definition of lot says it shall not be divided by a street.
Which
So-
it is intersected by it is crossed by a street. So I don't know how you could interpret it in a positive way.
Yeah, just to echo that, it's, those dimensions are meant for access.
This is her interpretation.
The interpretation.
Sorry, I don't mean to cut you off.
Yeah, when a street cuts through a lot, I just don't see that could work.
Okay.
Second.
So,
Either John or I seconded it, whoever said it first.
John,
Yeah, I
John
second that.
motion.
I second.
Okay, I didn't hear it. I'm sorry.
So I'll do roll call vote for Rose's motion. So, John, you're for Rose's...
For the motion from Rose.
Negative interpretation, right?
Negative
If that's the right
interpretation.
term?
Right.
All right, you're for the negative interpretation. Rose?
For the
you're
negative
it.
For the negative interpretation.
Joel?
4.
4.
And I'm for it as well.
So
So,
it's all in favor.
all in favor?
So the interpretation is
That the
denied.
negative interpretation.
And then the variance.
Okay, so now the variance.
Motion to deny the area variance.
Do I have a
Base.
second?
Second.
Okay, discussion.
Given the size of the lot and the lake frontage, I just don't see how anyone could park a boat and still have a 3-foot, I don't know how you could put a boat in when you have a 3-foot dock. I think it is a detriment to the nearby property owner. The fact that the dock moves a little bit, someone could be touching somebody else's house, I just don't see it. And I believe that the variance is substantial, and
Well,
it's
Rose, why don't you want to
self-created.
just go through the criteria?
Yeah,
So, number one as well, undesirable change in the character of the neighborhood or a detriment to nearby properties be created by granting of the variance.
yeah,
Yes,
detriment.
you just
I
explained.
just said
It'd
that.
be right up against the existing house, which has been there for however long.
Right.
Will an undesirable change in the character of the neighborhood take place? Yeah, because you're gonna be putting this dock that's oversized for the size of the lot that's there. The lot was 6 feet or
Well, that's 6 feet wide.
6 feet wide. So if you have a 3-foot dock and then a 10-foot or 8-foot wide boat, again, you're encumbering on the next door neighbor.
All you could have is a 3-foot boat.
Right. Number two, can any other method be used that does not require a variance but still allow for the benefit requested?
No.
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 Number three, is proposed variance substantial?
Yes.
Yes, because it's unfortunately 4 lots broken down into a smaller footprint lot that's not indicative of what's typical around the lake. I mean, it's probably allowed for access to the lake, but not conducive to building docks and having large boats on those docks, encroaching on the adjacent properties.
The minimum area is 3,000 square feet. They only have 280 square feet. That's significant.
Exactly.
Oh, yeah.
Substantial. So number four, will the proposed variance have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district?
I don't think so, because there's so many docks around.
And then finally, number five, is the alleged difficulty self-created?
Yes.
Yes.
Yes, it's
Once you go
trying to
through that,
create a
it's self-created.
situation.
And that's the problem, right?
So-
And just from something that I had said to them also, just going back to criteria number one, you know, if they would have gotten like a covenant, a permanent covenant to encroach on the condo's land, this is a different conversation. This is a much different conversation.
But the letter from the condo association said that they don't want them encroaching
It
on
did
their
say that.
property. So how
It did
do
say
you do that?
Right.
can't
They didn't
do
present,
that.
there was no presentation and evidence, unfortunately, to, for them to meet that criteria, so it has to go that way. So, I agree. You know, we were looking at the one property, but we have to talk about the other property too, which is the condo's property. They're also encroached upon.
Okay, any other discussion?
No.
All right, we'll do roll call vote. John, are you for the motion to deny?
Motion to deny, yeah, I'm for the motion to deny.
Rose?
For the motion.
For the motion.
For the motion.
For.
Four.
And I'm for the motion, so this gets denied. Okay, application number 3, Festo, we
Held over.
held over.
Although I really would like to dismiss it.
Number 4, Vukaj, we held over. Lily's out. Application number 5, Norman LLC, look for a
Held over.
motion.
Oh, nice.
Motion to grant?
Do I have a second?
Second.
Any discussion? All in favor?
Aye.
All right, application number 6, PNR Estate Corp.
Motion to grant.
Do I have a second?
Second.
Any discussion? All in favor?
Aye.
Okay, granted.
Which one?
Six was granted.
There's a use involved there.
Right, so we gotta do the secret on that. Okay?
Oh, we have to do secret on that. All right, so.
That's our 146.
We gotta do secret on it.
So what you should do is just go through the part 2 and just answer the questions, and then you can revote the determination.
After the
So
determination.
that you've made a determination after secret. All right.
Do you have one?
Mike, can you make a note to Dawn to, because I don't have that form. I actually have another blank one here we can
We
use.
have one, yeah, from the other one.
But going forward, like future meetings, if you can have her make a note. Well, if we're gonna require it for that
She had it.
applicant.
Could it be in the folder?
How about, Joe? I think I have an extra one
Actually, it
here.
could be in here.
This is for Vukaj. To who we doing
This is
No.
PNR, right?
Right, so the applicant,
That was part 1.
That's part 1, and then you go through part 2.
all right, I mean, I got a blank one from last month.
Did they do it at planning? Actually, I thought planning declared themselves as lead agency on that, so they'd be covered under them.
For which
You have
one?
to make a secret determination on the use.
Okay,
They are lead agency for the project.
okay. I'm looking to see if it's here.
You want me to read them out, Mr. Chairman?
No, but I mean, is there a form that we have to save as I'm checking these out?
You're gonna make the record.
Okay, so we don't need an actual form.
You don't have to write anything, you're just gonna ask the questions and answer.
Okay.
Oh, okay.
Why don't you go ahead, Greg? Read them out.
Okay, so take it as,
Speak into the mic, though, because Dawn always complains.
Okay, it's a short form EAF, Part 2, the impact assessment. And the first question is, will the proposed action create a material conflict with an adopted land use or planning or zoning regulations? You just say yes or no, moderate impact, small impact, or moderate
I
to
don't
large.
think so.
No.
No.
Will the proposed action result in a change in the use or intensity of use of land?
No.
No.
Will the proposed
No, it's a
action
decrease.
impair the character or quality of the existing community?
No.
Will the proposed action have an impact on the environmental characteristics that cause the establishment of a critical environmental area, or CEA?
No.
No.
Will the proposed action result in an adverse change in the existing level of traffic or affecting existing infrastructure for mass transit, biking, or walkway?
Negative.
Will the proposed action cause an increase in the use of energy and it fails to incorporate reasonably available energy conservation?
No.
Or renewable energy opportunities? Is that a no?
No.
Okay. Will the proposed action impact existing public or private water supplies? Or public or private wastewater treatment utilities?
Yes, minor, because that's why they need the septic, don't they? Oh, no, that wasn't this case.
No.
No, that's
That's
different.
sewer there.
No.
That's sewer there,
Sewer
right?
up there, no.
So
Will
no.
will the proposed action impair the quality of important historic, archaeological, architectural, or aesthetic resources?
No, he's
No.
not changing the outside of the house.
Will the proposed action result in an adverse change to natural resources, wetlands, water bodies, groundwater, air
No.
quality, flora, and fauna? No. Will the proposed action result in an increase in the potential for erosion, flooding, or drainage problems?
No.
Nope.
They haven't done any land
Will the
change.
proposed action create a hazard to environmental resources or human health?
No.
No.
Okay. So in that circumstance, if you answered no or small impact to all the questions, somebody can make a motion to adopt a negative declaration.
I'll make a motion to adopt the negative declaration.
Second?
Second?
All in favor?
Aye.
Now you can vote
So
on
now
the
we
merits of
revote
the
it.
application.
I lost my agenda.
Here.
So Pinar Estate Corp., look for a motion.
Motion to grant?
Second.
Do I have a second? All in favor?
Aye.
Okay. Application number 7, AFC Urgent Care, look for a motion.
Motion to grant.
Do I have a
Second.
second? Any discussion? All in favor?
Aye.
And number 8, we held over.
Held over.
All right, meeting minutes from November 2nd. That's the meeting I was not here.
Yeah, but if you read them, you can vote.
Motion to approve as amended?
Do I have a second? All in favor?
Aye.
And minutes from November 30th, 2023. For a motion?
Motion to approve?
Second.
Second, all in favor?
Aye.
And minutes from December 21st, 2023.
Motion to approve.
Second.
Second, all in favor?
Aye.
Okay, motion to close this meeting.
So moved.
Second.
Do I have a second?
Second.
All in favor?
Aye.
Good night, everybody.